Good afternoon, ladies and gentlemen. I'm pleased to be here today to talk about the GI systems in Singapore. My presentation is divided into 5 parts. I'll start with the legislation governing GIs in Singapore. I'll then go through the registration process. Next, we'll find out how homonymous GIs can be registered in Singapore. And finally, I'll share with you the concept of qualification of rights and limitation of scope, both of which are unique concepts in Singapore. To get started, let's look at the legislation governing GIs in Singapore. The 2014 GI Act and its subsidiary legislation, the 2019 GI Rules, form the legislation governing GIs in Singapore. The GI Act and the GI Rules came into force on 1st of April 2019, and the GI Registry became operational on the same day. The GI Registry is administered by the Intellectual Property Office of Singapore, and the GI Registry is the office that receives applications for registration of GIs. While it is not compulsory to register for GI, the benefit of registration is that all registered GIs enjoy enhanced protection, where GI labels cannot be used on products which do not come from the place indicated by the GI, even if the consumers are not misled as to the true geographical origin of the goods in question. Unregistered GIs are also protected under the 2014 GI Act, and the level of protection is consistent with the 2 levels of protection offered in the TRIPS agreement. Another benefit of registration, which has been shared by Dr. Delphine earlier, is that producers and traders in respect of registered GIs will have access to border enforcement measures, such as being able to request the Singapore Customs authorities to detain suspected infringing goods which are to be imported or exported from Singapore. However, do note that these improved border enforcement measures, which have been introduced in the 2014 GI Act, were only implemented within 3 years of the entry into force of the EU-Singapore FTA. Moving on, let's go through the registration process in Singapore. Registration is a 3-stage process that seeks to be fair and transparent. The process is similar to the trademark registration system in Singapore. Firstly, an application for registration must be made. Second, the application will be examined to ascertain that it fulfills the criteria for registration. Third, assuming that the application satisfies the registration criteria, it will be published for a period of 6 weeks to give third parties an opportunity to object to the registration. The GI will proceed to registration if no opposition is received. Let's go through the 3-stage process in more details. First, an application for registration of a GI must be made in Form GI1, which can be downloaded from IPOS website. The GI registry will accept applications from anywhere in the world. However, only certain categories of persons are entitled to file an application for registration of a GI. They include producers of GI products, associations of such producers, and the relevant competent authorities. There is no restriction as to the nationality or country of incorporation, but the applicant must provide an address of service in Singapore to which the GI registry may send correspondence relating to the application. These are the requirements for an application for registration of a GI. The application will not be accepted unless all the information are provided and the requirements are satisfied. Applications for registration can be made in respect of wines and spirits and selected categories of agricultural products and foodstuffs. I'll pause for a while for you to go through these 14 categories of goods. The second stage of the registration process is where the completed application form is submitted to the GI registry for examination. The application will be examined to determine if the GI is registrable in accordance with the law. You may be wondering, what does a GI examiner look out for during examination? These are some of the factors the examiner will consider as part of the examination process for GI applications. The list you see on the screen is non-exhaustive. For the complete list, you may want to refer to Section 41 of the 2014 GI Act. For the last point, the GI registry will follow the first-in-time, first-in-right principle. Generally speaking, this means that a prior conflicting trademark may prevent the registration of a subsequently conflicting GI. However, the later GI can still be registered if consent is obtained from the owner of the prior conflicting trademark. If the requirements for registration have been made, the application will be published for public inspection. The GI journals are published online at the IP2SG website. Third parties may give notice of their opposition to the registration within 6 weeks after the date of the publication. For a GI application that encounters opposition, the opponent and the applicant of the GI application are required to file the necessary arguments and evidence to oppose and defend the opposition respectively. Subsequently, an opposition hearing will be held to determine the merits of the opposition. Whether the GI application can proceed to registration thereafter will depend on the outcome of the opposition hearing. The GI will proceed to registration if there is no opposition or if the outcome of the opposition is in favor of the applicant of the GI. The duration of the registration of a GI will be 10 years from the date of registration. The GI may be renewed for further periods of 10 years. As of 1st of November this year, 141 GIs have been successfully registered in Singapore. It's worth noting that 50% of the GIs that are registered are for wines, 14% of the registered GIs are cheese, while spirits accounted for 13% of the GIs that have been registered. Now I would like to move on to talk about homonymous GIs. A homonymous GI is a GI that in part or in whole has the same spelling as or sounds the same as a GI for any goods having a different geographical origin. Homonymous GIs often occur when regions in different countries share the same name and produce goods with specific qualities or characteristics essentially attributable to the respective regions. Homonymous GIs can be registered in Singapore even if the similarly spelled or similarly sounding GI has already been registered. To avoid consumer confusion as to the true origin of these goods, the registration of such homonymous GIs may be imposed with certain practical conditions so as to differentiate the GIs. An example of a practical condition is ensuring that food labels, packaging, or marketing collaterals clearly indicate the country of origin. The applicant and registrant for the homonymous GIs will have to communicate with each other and try to reach an agreement on the practical conditions. Where the registrar decides to impose the practical conditions will be imposed on all the homonymous GIs in question. So let's now take a look at qualification of rights. The Singapore GI system has incorporated the concept of qualifications under Section 46 of the 2014 GI Act. This enables any party to request for qualification of rights conferred to a registered GI in relation to any name contained in the GI or any term which may be a possible translation of the GI. For example, a request may be made to qualify that a certain term is not a translation of the registered GI. This is because GIs come from many different countries and their names are usually in their native language. A qualification of rights is thus useful to clarify what is or what is not a translation of the registered GI. A request for qualification of rights may be submitted at any time after the date of the publication of the application for registration of the GI, but before the GI is registered. The request for qualification of rights is open to anyone, and this can be the applicant of the GI or any third party. However, it should be noted that the request for qualification of rights may not be filed if they seek to qualify all the rights conferred on the GI. This is because the qualification of rights process is intended to enable one to clarify the scope of protection conferred by the registration and not to negate the GI registration altogether by wholly removing the rights conferred by registration. In such a case, instead of making a request to enter a qualification of rights in the register, a notice of opposition to the registration of the GI or variant constituting the GI should be lodged before the registration of the GI. The proposed qualification of rights, if accepted by the registrar, will be published in the GI journal. Any person who claims the person's interest will be affected by the proposed qualification of rights may file a notice to oppose the qualification of rights. Where a registered GI is subject to qualification, the rights of the interested parties to that GI will be restricted accordingly. So what happens if parties still wish to limit the scope of rights conferred to the GI after the GI has been registered? So once the GI is registered, parties would need to apply for limitation of scope if they wish to limit the scope of rights conferred on a registered GI. A limitation of scope application can only be filed after GI is registered, and the application must be filed with the High Court. The applicant may seek a limitation of scope in relation to any name contained in the GI or any term which may be a possible translation of the GI. Similar to a qualification of rights, a limitation of scope could not be used to negate the registration of a GI entirely. In such a case, instead of making an application for an order to enter a limitation of scope in the register, an application for cancellation of the GI or variant constituting the GI should be made. So this is the end of my presentation. So just let me sum up my main points. Singapore's registration process for GIs is a three-stage process that seeks to be fair and transparent. I also spoke about homonymous GI. Homonymous GIs may be registered with practical conditions. The relevant parties for the homonymous GIs will have to agree on the practical conditions to be imposed. I've also shared about the concept of qualification of rights, where anyone can file a request for qualification of rights before the GI is registered. Qualification of rights will help to clarify what is protected or not protected by the registered GI. Once a GI has been registered, any person may apply to the courts for an order that the limitation of the scope of rights conferred in respect of a registered GI be entered in the GI register. The nature of clarification sought and the grounds on which to file a limitation of scope request mirror that of the qualification of rights request.